Hi, I'm Paula Vincent Johnson, a Louisiana civil law notary. I help Louisiana residents get their essential estate planning documents in order. If you are an individual, couple, family caregiver, or business owner seeking information about powers of attorney, wills, successions, and real estate transfers, stick around. Today I'm going to talk about opening succession. When a person dies, they leave behind assets which must be distributed to their heirs. This is their estate. An estate is everything a person owns on the day he or she dies. That's property, cars, money, jewelry, clothing, household items, and intellectual property such as a person's rights in books, art, or music, intangible things. A succession is the legal process of wrapping up a decedent's estate and distributing or transferring title of their assets to the people who inherited them. Some people think a succession does not have to be done if there was a will. That's a misconception. With or without a will, ownership of the decedent's assets still have to be transferred to his or her heirs. A succession with a will is called a testate succession. Testament, testate. The person in charge is called the executor. If there is no will, then the succession is called an intestate succession, and the person in charge is called an administrator. Executor indicates there was a will. Administrator indicates there was no will. Opening succession means the executor or administrator will begin the legal process of wrapping up the estate so they can distribute the decedent's assets. The first step is to determine whether the decedent had a will. Now, the family should have some idea because usually the decedent will have talked with someone about their wishes. If you're not sure, you can always check with the Louisiana Secretary of State's office to see if the decedent's name is on the will's registry. The state does not have a copy of the will, but they keep a list of people who have filed a form indicating they do have a will and where it might be found. I put a link in the description below. If there is no will, how you handle the succession will depend on the value of the decedent's estate. If everything the decedent owned is valued at $125,000 or less, I may be able to help you with the affidavit of small succession process, which does not require going to court. There's a link in the description if you'd like to schedule a consultation with me. Now, if there is a will, then the executor needs to secure the original as soon as possible. This is critical. In order to successfully conclude the succession according to the decedent's wishes, the original will must be submitted to the court. The next step is to start gathering information, which includes the names, addresses, and telephone numbers of anyone named in the will to receive an inheritance, the decedent's children, the surviving spouse if there is one, the municipal addresses of any property the decedent owned, names of financial institutions, title to vehicles or boats. You get the idea. You want to start collecting as much documentation as you can to prove what the decedent owned at the time of death. You would provide that information to me as a notary in a small succession. However, if there is a will or if the value of everything the decedent owned is more than $125,000, even without a will, then the family needs to hire an attorney. He or she will guide you on any additional information they need. And if there is no will naming an executor, the attorney will file documents with the court to have an administrator named. A judge makes the final decision about who's going to be in charge. The administrator will do the same job as an executor. Also, any accounts that have beneficiaries, such as life insurance, annuities, retirement accounts, or payable on death accounts, do not go through the succession process. The money will be distributed directly to the beneficiary. The institution holding the money will guide you on their requirements. The main reason people open succession is to gain access to bank accounts and clear title to real estate so it can be mortgaged, sold, or donated. In my opinion, you should open succession as soon as the family feels emotionally ready to do so. Don't wait until the last minute. It takes time. I can conclude the small succession process with my clients in 2 to 6 weeks, depending on how many heirs there are and whether any of them live out of state. However, judicial successions, meaning through the courts, can take 2 to 4 months if there are no issues. If there are complications, judicial successions could take years. If you learned something and you like the information that you just received, then click the thumbs up button to like this video and subscribe to this channel. You'll be helping other individuals, couples, family caregivers, and business owners find this information more quickly. And don't forget to click that bell so you know when new information is available. Please visit my website, and you can follow me on Facebook and Twitter, where I give quick answers to your quick questions. When you connect with me, I promise you'll learn something. Thank you for watching. I appreciate you. I'm Paula Vincent Johnson. Come back to see me next week.